discussed with regard to relationship between a banker and a customer. So today in this video we'll be dealing with special features of the relationship between a banker and a customer. This can be discussed under two heads, that is obligation of a banker and rights of the banker. So taking the first one, that is obligation of the banker, there are two obligations that a banker has to follow. The first one is to honor the checks and second one is to maintain secrecy. First obligation, as said, is to honor the checks. We know that the primary function of a bank is to accept deposit so as to lend the funds when demanded by the customer. 31 of the Negotiable Instrument Act clearly states that a drawee should honor the check when there is a sufficient balance in the drawer's account, which means when a check is drawn by the customer on the bank, the payee is the third person. So here the banker has a responsibility or obligation to honor that particular check when there is sufficient balance in the drawer's account. However, there are few conditions that has to be fulfilled. That is, the banker should take care of few things. Now what are they? The first one is that the customer's account has sufficient balance. So when a check is drawn on a banker, the banker makes sure if there is sufficient balance in the customer's account to honor such check or not. Second one is with regard to presentation of the check. Now what do you mean by presentation of the check is nothing but on whom it is drawn. Third person has to get the check to the banker during the banking hours, that is proper time and proper place in the banking premises during the proper time. The next one is with regard to the signature. That is, a banker should make sure the signature is of the customer himself, or is it a forged signature? So this responsibility is on the banker. If in case he finds that it is a forged signature or a signature of a third person, then he need not honor such checks. Same rule applies when it is a mutilated check. Now what you mean by mutilated check is a torn check or altered check, or something is cancelled in that particular check or rewritten in the check. In such cases, the banker need not honor the check. Next condition is in case of partnership firm or company accounts, wherein there are certain authorized persons to sign the check. However, if any third person other than the authorized persons signs the check, in that case the banker need not honor the check. Also, when there is existence of legal bar. Now this legal bar is nothing but law requires the banker to freeze the account of the customer. In such cases, the banker cannot honor the checks. The second obligation of a banker is to maintain secrecy. So when it comes to the account details or banking affairs of the customer, the banker should make sure that he doesn't throw open into the public all the details that belong to the customer or customer's account. The banker-customer relationship is based on, or the foundation for this is confidence and secrecy. However, in few cases, disclosure is justified. So which are those cases? The first exception is when the disclosure is made as a compulsion by law. That is, law requires it to be disclosed. So when law makes it compulsory or mandatory for a banker to disclose certain things, it becomes the statutory obligation of a banker to disclose the same truth. For example, under the Income Tax Act or Bankers Book Evidence Act, Bankers Regulation Act, or also when RBI calls for the information, the banker has to produce the ledger and also the customer account details to the authority. The next exception is when it is in the interest of the public. That is, if in case the account is of an alien enemy, or maybe the amount in that particular account is being used for unlawful business or unlawful activities and it is against the security of the nation. In that case, the banker is bound to disclose such details of the customer's account. Also, when there is express or implied consent that is given by the customer to disclose the details of his own account, especially when it comes to the auditors or referee or a guarantor. At that point of time, the customer can give the consent to the banker to disclose the details to the said persons. Even in this case of disclosures, that is, exceptions are given for a banker wherein he can make certain disclosures. But even in that case, a banker should follow certain precautions. The precautions are very simple. The first one, he should not act negligently. He should take due care. And the second one is that when he is disclosing certain facts, it should be the truth or the fact that he is disclosing. He should not give any misleading information. In case of unjustifiable disclosure, that is, if he is giving some wrong information about the customer's account, in that case, the banker will be held personally liable for both the third party and also the customer. So that's about the obligation of the banker. Now moving on to the rights of the banker, there are three rights of a banker. The first one is banker's right of general lien. Second is banker's right to set off, and third is banker's right for appropriation. We'll be now discussing with regard to these three rights in detail. So the first one is right of general lien. Now we need to know what is lien. Lien is nothing but right to retain certain goods. When you consider a loan that is given by a banker to the customer, it is given against a collateral or a security. So when the loan is repaid, the security is given back. What happens if the loan is not repaid? In that case, the banker has a right to retain that particular property or security given for that particular loan. Now this right to retain is called as right of lien. There are two kinds of lien. First one is the particular lien and general lien. The particular lien is wherein the right to retain a certain goods against particular debt is given. Whereas in case of general lien, any goods or all the goods can be retained until the claims are satisfied. Bankers, factors, attorneys, policy brokers or wharfingers are given with this right of general lien. In case of a banker who is exercising his right of general lien, he needs to follow certain conditions. And the conditions clearly state that there shouldn't be any agreement inconsistent to this right. At the same time, he has received all these securities lawfully in the capacity of a banker itself. The banker's lien can be attached to the following securities. That is, if in case it is a check or bill of exchange given for collection with a banker, or the deposits or the securities which are given against certain debt or loan to the banker. Also, in case of securities that is purchased by the banker on the instance of the customer and which are still in the possession of a banker. However, a banker cannot exercise his right of lien against any safe custody deposits. That is, if the customer is keeping his valuables or deposits in the safe custody of the banker, there the banker cannot exercise his right of general lien. Also, if the goods or securities are left by mistake by the customer with the banker, in that case the banker will not have a right of general lien. If the bills of exchange or securities are given for specific purpose, in that case the banker cannot exercise the right of general lien. One more thing we need to note is that right to retain or right of lien can be exercised by the banker only when the loan is due or the debt is due and not before that. The second right of a banker is right of set off. So if you consider a debtor and a creditor, the legal right of a debtor is that when the debtor has to repay certain amount, what the debtor will do is, if in case the creditor also is owing certain money to the debtor, he will deduct that amount and the rest of the amount or the remaining amount is repaid to the creditor. In case of a banker and a customer, when the banker has to repay the amount, what the banker does is, he deducts the amount which the customer owes to the banker. For example, a customer has two accounts. One which he has overdrawn, that is, he has drawn beyond the limit, and in second account he has certain credit. Now when the banker has to repay the amount in the account wherein the credit is remaining, what he does is he deducts the amount which is already overdrawn by the customer. The banker here combines two accounts, that is the overdrawn account and the account which has the credit. After combining and deducting, whatever is the remaining amount, that is repaid to the customer. For example, you have to give your friend rupees 70 and your friend had to give you rupees 50. So now what you do is you combine these two accounts and you give just rupees 20 to your friend. So this is called as set off. Similarly, the banker will combine an overdrawn account and the account which has credit and set off. So whatever is the remaining amount, that will be repaid by the banker to the customer. However, there are few conditions that a banker should take care of when it comes to write-off set-off. The first condition says that the account of the customer should be in the same name and in the same right. Now what do you mean by same name and same right is that two accounts should be the personal accounts of the customer. That is, if one account belongs to the company wherein he is working and second account is his personal account. So in the case of company's account, if it is overdrawn, that cannot be adjusted against the personal account of the customer. So it should be in the same name, in the same right, the personal capacity itself. The second condition is that before such set-off is done, the customer should be given a notice. He should be priorly informed about such a set-off. The third condition clearly states that it cannot be with regard to future debt. That is, if in case he might or he may withdraw in the future or overdraw in the future, in such cases set-off is not allowed. It should be the present debt or existing debt and not the future debt. The next right is banker's right of appropriation of payments. Now, appropriation of payments is wherein the customer has two or more debts taken from the same banker. So, the customer has taken two or more debts by a certain banker. Now, when he is repaying that debt or loan, he does not give any instructions. So, the banker can appropriate it. That is, the banker can take the repayment against one loan or he can appropriate against any of the loans which is taken by the customer. So, he has a right to appropriate, but the right of appropriation arises only when the debt is repaid without any instructions. So, today in this video we discussed with regard to obligations of the banker and also rights of the banker. I hope you're clear with the concept.